Hi students, welcome back to yet another video of business regulation. Today we are going to discuss the topic capacity to contract. Here capacity means a person's legal ability to enter into a contract. So capacity or competency of the party is an essential requirement of a valid contract. In short, we can say that the parties who enter into a contract must have the capacity to do that contract. Section 10 says that an agreement becomes a contract if it is entered into between the parties who are competent to contract. Section 11 of the Indian Contract Act deals with the competency of the parties. It states that every person is competent to enter into a contract if he has attained the age of majority according to the law to which he is subject, and who is of sound mind and is not disqualified from contracting by any law to which he is subject. So this is the meaning of capacity to contract. I repeat, section 11 says that every person is competent to contract who is at the age of majority according to the law to which he is subject, and who is of sound mind and is not disqualified from contracting by any law to which he is subject. So while analyzing this definition, we can understand that capacity of a contract means legal competency of party to enter into a contract. Thus, every person is legally competent to contract if he fulfills three conditions. In other words, if a person possesses three qualities, he can make a contract. So the qualities are: he has attained at the age of majority, he is of sound mind, he is not disqualified from any law. That means if a person attained at the age of majority and he is sound mind and not disqualified from any law can make a contract. So this is the three quality which must be possessed by a person while making a contract. Now we can discuss some persons who is incompetent to make a contract, or the person who is disqualified from entering into the contract. They are minor, persons of unsound mind, and persons disqualified by any law. So these three categories are not competent to enter into a valid contract. Now we can discuss each of this category in detail. So minor is the first category. He is not competent to enter into a contract. A minor is the person who has not attained the age of majority. I repeat, a minor is a person who has not attained at the age of majority. Generally, we can say that an agreement with the minor is void ab initio, which means from the beginning of the contract with the minor itself is not valid. It is void. According to the Indian Majority Act 1875, a minor is one who has not completed his or her 18th year of age. So we can say that a person attained majority on completing his 18th year in India. But in some cases, a person continued to be a minor until he completes the age of 21 years. That means some cases 18 year is not adequate. The person who must attain 21 years for attaining his majority. So the cases are where a minor person's property is under the Guardian and Ward Act 1819, and where the minor's property has been placed under the superintendence of a court ward. In these two cases, a minor must complete 21 years to attain his or her majority. I repeat, a minor person's property is under the control of a guardian, or a minor person's property has been placed under the superintendence of a court ward. These two cases, person must attain 21 years to attain his or her majority. In England, a minor is called infant, and therefore minority is known as infancy. Under the English law, a person becomes major when he has completed 18 years of age. So once again we can say that a minor is a person who has not attained the age of 18th year. Now next is the rules governing judicial philosophy as to minor. Before discussing the law relating to minor, we must look the three fundamental rules governing judicial philosophy towards minor. They are: the law must protect the interest of the minors, the law should not cause unnecessary hardship to the other party, and enforcement is possible if minor is a beneficiary or promisee. So take the first one. The law must protect the minors against their own inexperience, preserve their rights and properties, excuse their negligence, and assist them while making arguments. Next rule is the law should not cause unnecessary hardship to the other party. While dealing with the minor, the law should not cause unnecessary hardship to the person who deals with the minor. Thus, in minor case, the law must behave like his guardian. Now, the last rule is enforcement of agreement is possible if minor is a beneficiary or promisee, which means minor can continue the agreement against the other party if he is a promisee or beneficiary in the agreement. Now, we have a look on the position of a minor as regards his agreement or the effects of minor's agreement, or in other words, the law relating to minor's agreement. So, first we can say that an agreement with a minor is void ab initio, which means a contract with a minor is absolutely void in the beginning itself. So, it is the first rule or law which is related with the minor's agreement. I repeat, a contract with a minor is absolutely void in the beginning itself. However, the minor may enforce the agreement against the other party if he has carried out his obligation. Now, the second one is ratification on attaining the majority is not allowed. Here, ratification means approval or confirmation. A minor cannot approve a promise which is entered during his minority. Now, the third effect of minor agreement is minor can always plead his minority. Minor have a right to make argument that he is a minor to avoid the contract. But always remember that even though the law given protection to the minors, it does not give them the right to cheat men or cheat others. Now, the next effect on minor agreement is a minor is not liable to restore the property or goods. Restoring means giving back. If a minor make a contract and enjoy benefit out of it, he is not liable to repay the money, or in other words, a minor is not liable to make any compensation for any benefit he received under the void contract. Next is no specific performance of the agreement. A minor contract is absolutely void, so the court cannot direct specific performance of such an agreement. Next effect on minor agreement is minor can be promisee or beneficiary. If a contract is beneficial to a minor, it can be enforced by him. There is no restriction on a minor to act as a beneficiary or promisee. If in a contract, minor is a beneficiary or he suffered loss or he is a promisee, he can demand the discharging of the contract. Therefore, we can say that agreements entered by a minor for his benefit are valued and enforceable. Now, the next point is minor as a partner. According to section 30 of the Partnership Act 1932, a minor cannot become a partner in a partnership firm because he is incompetent. But if all other members of partnership agree, minor can be admitted to enjoy the benefits of the firm. He cannot be a partner in the true sense. He has no voice in the management of the firm. He has no right to inspect the books of account kept by the firm. Now, next is minor can be an agent. A minor can act as an agent, but he will not be personally liable for his act. Next effect is minor cannot be treated as insolvent. No one can declare a minor as an insolvent. If any debt has been incurred during his minority, the minor is not personally liable for such debts. Now next one is position of surety. Anyone who give guarantee on behalf of minor is liable for any debt or payment of the loan for the minor. So minor is not liable. The person who stand on behalf of minor is always liable to pay debt or any other loan. Now next is minor's liability for necessaries. Minor is liable to pay a reasonable price for the necessaries supplied to him. His property is liable, but he is not personally liable. So this is the another rule. Now next is position of minor's parents. The parents are not liable for the contract entered into by the minor himself. They are liable only if minor is their agent. Now next one is minor as a shareholder. A minor cannot become a shareholder, but through his guardian he can purchase the share. Next is a minor is liable for necessaries supplied for necessary service rendered to him. Here necessary goods include bread and clothes, watch and bicycle, etc. Necessary services include education, training, medical advice, legal advice, etc. So these are the main rules relating to minor's agreement or the position of minor in his agreement. Now we can discuss the questions which is related with this area. So they are: what do you mean by competency of contract? Name the person who are competent to enter a contract. Explain the fundamental rules governing judicial philosophy towards minor. Who are the person incompetent to make contract? State and explain the law relating to contract by minors. A minor has no privilege to cheat others. Explain. Can a minor be declared insolvent? Can a minor act as an agent? So students, today we discussed the concept capacity to contract and one category of person who has no capacity to enter the contract. That is minor. Now the remaining persons are persons of unsound mind and persons disqualified by other law. So we can discuss these two in the next class. Hope you all get a picture regarding capacity to contract. So see you in the next class. Thank you.